Hello and welcome to the Data Engineering Podcast, the show about modern data management. When you're ready to build your next pipeline or want to test out the projects you hear about on the show, you'll need somewhere to deploy it, so check out our friends over at Linode. With 200 gigabit private networking, scalable shared block storage, and a 40 gigabit public network, you've got everything you need to run a fast, reliable, and bulletproof data platform. And if you need global distributions, they've got that covered too, with worldwide data centers, including new ones in Toronto and Mumbai. And for your machine learning workloads, they just announced dedicated CPU instances. Go to dataengineeringpodcast.com/Linode, that's Linode today to get a $20 credit and launch a new server in under a minute. And don't forget to thank them for their continued support of this show. This week's episode is also sponsored by Data Coral, an AWS native, serverless data infrastructure that installs in your VPC. Data Coral helps data engineers build and manage the flow of data pipelines without having to manage any infrastructure, meaning you can spend your time invested in data transformations and business needs rather than pipeline maintenance. Raghu Murthy, founder and CEO of Data Coral, built data infrastructures at Yahoo and Facebook, scaling from terabytes to petabytes of analytic data. He started Data Coral with the goal to make SQL the universal data programming language. Visit dataengineeringpodcast.com/datacoral today to find out more. And having all of your logs and event data in one place makes your life easier when something breaks, unless that something is your Elasticsearch cluster because it's storing too much data. Chaos Search frees you from having to worry about data retention, unexpected failures, and expanding operating costs. They give you a fully managed service to search and analyze all of your logs in S3 entirely under your control, all for half the cost of running your own Elasticsearch cluster or using a hosted platform. Try it out for yourself at dataengineeringpodcast.com/chaos search, and don't forget to thank them for supporting the show. You listen to this show to learn and stay up to date with what's happening in databases, streaming platforms, big data, and everything else you need to know about modern data management. For even more opportunities to meet, listen, and learn from your peers, you don't want to miss out on this year's conference season. We have partnered with organizations such as O'Reilly Media, Corinium Global Intelligence, Alluxio, and Data Council. Upcoming events include the Data Orchestration Summit and Data Council in New York City. Go to dataengineeringpodcast.com/conferences to learn more about these and other events, and take advantage of our partner discounts to save money when you register today. Your host is Tobias Macy, and today I'm interviewing Karen Heaton and Mark Sherwood-Edwards about the idea of data protection, why you might need it, and how to include the principles in your data pipelines. So, Karen, can you start by introducing yourself?
Yes, good afternoon. My name is Karen Heaton. I run my own data protection consultancy. I've been working in data and systems implementations in financial services for over 20 years. And I'm a real fan of technology. And now my consultancy obviously specialises in data protection compliance for mainly small and medium-sized organisations, including tech startups.
And Mark, can you introduce yourself as well?
Sure. My name is Mark Sherwood-Edwards. I'm a tech lawyer by background. I now do a lot of work in the privacy space, and I've got a privacy business called thisisdpo.co.uk. Like Karen, I'm based in London, UK, and like Karen, we both do a lot of work sometimes together around the GDPR. My background, as I said, is as a lawyer, primarily in technology, outsourcing, intellectual property, those kind of areas.
And going back to you, Karen, do you remember how you first got involved in the area of data management?
Well, yes. Ever since I first started working, which is quite a long time ago, I've always been involved in systems and data, whether I've been working in operations for banks or other different types of companies, or whether I've been working for software companies, helping them implement their software solutions into their clients' organizations. So data and systems has been a very large part of my life. And now with the data protection regulations coming in, these elements are now marrying together into a very interesting topic area. So that's many years of experience in this area.
And Mark, do you remember how you got involved in data management?
Yeah, well, probably not quite as directly as Karen's, but so I've been in-house counsel for a number of outsourcing companies over the years. Some of them do a lot of HR, some a lot of procurement, all of it involving a fair amount of data. So I've always been quite interested in it, and the kind of interrelationship between data and intellectual property, whether you own data, can't own data, has always been an interest of mine. So that's been going on for quite a number of years now.
It's been interesting because Mark and I often talk about how we've, given our ages, how we've enjoyed watching technology grow from the days of very large mainframe computers, punch cards, all the way up to what we have today with a plethora of apps and now, artificial intelligence and machine learning. So we both feel very privileged, actually, that we've been able to watch the growth of systems and data over the last 30 plus years.
And as you mentioned, in recent years, there have been some regulations coming out that cover this idea of data protection. So I'm wondering if you can start by explaining a bit about what that term means and what it encompasses from the perspective of data storage systems and data management.
Okay, well, I'll kick off on that one. So when people talk about data protection, they're talking essentially about personal data, the protection of personal data and the regulation of personal data. Now, most people nowadays are aware of the GDPR, which came out in the European Union last year, but which has impact outside the European Union as well. We can talk about that a bit later. But GDPR wasn't particularly new, at least in Europe. Data protection has been around for 20 to 30 years. And it starts really with human rights. In fact, the European Convention of Human Rights, Article 8, says everyone has the right to respect for his private and family life, his home and his correspondence. And that's the respect for your private life. And the data you use and create being seen as part of your private life is where it all starts from. Interestingly, I took the opportunity to look at some corresponding US documents. And the US Constitution, the one that starts off, "We the people," as you will know, Tobias, goes on, "We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility." And that ensure domestic tranquility is possibly, I'm not a US constitutional lawyer, you'll appreciate, is the same kind of concept, how one protects private life. So the general concept has been around for a long time, and that is it's fine for companies to take and use other people's or their customers' personal data, which they may collect because people enter an account or it's a bank or you may be shopping on Amazon or whatever, provided they do that lawfully, transparently, and in a fair way. And essentially that means if you're disclosing your personal data to someone else or to a company, they've got to be very explicit about what they're going to do with it and not do things which they haven't disclosed ahead of time. And if that's the case, broadly, then what they do is going to be lawful and everybody's going to be happy with it. Another way of looking at it is a trust-based thing. Okay, we consumers are trusting companies with our personal data, and having entrusted them with that data, we are expecting them to respect that trust by acting lawfully, transparently, and so on. So essentially, data protection is a codification of a trust-based principle, and that's the high-level view. And then you can dig down to various low-level views as we progress.
And in terms of the actual specific regulations, as you said, it's a concept that's been around for quite a while, but in recent years, we've been more explicitly codifying it in the GDPR and then recently in California with the CCPA. I'm wondering if you can just discuss a bit of the scope of those regulations and how an organization or an individual can best determine whether or not they're subject to those rules and what particular information is encompassed by that.
Okay, well, both the GDPR and the CCPA are essentially rules about personal data and the use of other people's personal data. So to that extent, they're very similar and they have a lot of concepts in common. Some of the concepts in common, for example, apply both in GDPR and CCPA. If you're going to use other people's personal data, your consumers' personal data, you've got to tell them that's what you're doing. There's generally privacy notice says, yeah, we're using your personal data. These are the categories of data we're going to use, and these are the purposes we're going to use them for. Okay, and and that applies both across the CCPA and GDPR. Both equally have a right for the relevant consumer to get access to their data, i.e. a copy of the data that's been held about them, and both have the right for consumers to get their data deleted. Now, then the differences start to come. So the GDPR is the kind of product of a longer thinking. Not only was there preceding regulation from 1998, it had a longer gestation period. The CCPA was put together in a bit of a rush to meet a deadline. So some of the fundamental differences are you get concepts in the GDPR like lawful basis. Okay, so it's a finite amount of law. There's, I think, 6 lawful bases under GDPR. And if you're processing personal data means it's more or less the same in both categories. The US tends to call it PII, personally identifiable information. Europe calls it personal data. They're very broad categories, include your name, your email address, your phone number, but also online identifiers, things like that. Anything which can be tracked back to you on a kind of one-to-one basis. So both have that in common. The GDPR has this notion of the lawful bases, and you have to have a lawful basis to handle personal data, and you have to explain which lawful data bases you're using. For example, have you got consent? If you don't have consent, is it pursuant to contract? If it's not that, is it pursuant to legitimate basis? That kind of stuff. The GDPR also has some more fundamental concepts kicking around in it. Things like privacy by design and data minimization. Privacy by design means kind of what it says. It's kind of the evolution of data protection in the early days. And now the general thinking is if you've got any system, by which I mean not just hardware, software, but people around the system, and you're going to be handling personal data, processing personal data, then you need to have thought out how you're going to build in privacy requirements from the start. It's no longer okay just trying to retrofit it afterwards. Data minimization means a couple of things. What's the minimum amount of data that you need to accomplish the job, not what's the max amount of data. And then once you have that data, when you use it in your business, using the minimum amount for each particular job, not just sharing data around like confetti. So those are some structural, fundamental things which are explicitly called out in the GDPR and not explicitly called out in CCPA. The CCPA's approach is much more an opt-out approach. Most things are permitted, but the primary thing is, and it applies to Californian residents and most companies dealing with Californian residents. But if it applies to you, you have the right to opt out of what they call selling of data. So you can object, you can't sell my data. And effectively that means selling is a broad term for any kind of sharing, licensing, and so on of data. So those are the kind of they're similar in some ways. They've got some fundamental underpinnings, tectonic plates, which are slightly different, but they'll end up driving the same kind of behavior probably for businesses over time, which is be more careful with personal data, essentially.
And I think, Tobias, you also asked about the territorial reach of GDPR.
Yeah, some of the ways that you can determine whether or not the data that you're dealing with is actually subject to these regulations. And I think that the blanket approach that a lot of companies are taking is that it's too hard to identify at a granular level whether or not somebody is a European citizen or is in some way related to the European Union or California. And so they just apply these same sets of principles in a blanket sense. And I'm wondering what your thoughts are on some of the sort of best strategies to approach the regulatory environment that we're in now.
I'm sure most people have seen evidence of big American companies in particular undertaking compliance programs, signing up to the US Privacy Shield to show that they have adequate data protection standards, and even doing things like updating terms and conditions, privacy notices. MailChimp, for example, have introduced something called double opt-in function into their platform, so that consent is of a GDPR standard for any of their clients in the EU. So if you don't want to adopt a blanket approach, it comes down to then truly being able to try and understand in a granular way what data you have in your data sets, how you acquired it, what you're going to use it for, whether your organization actually does sell products and services into the EU, in which case they will definitely be subjected to the regulations, or even if they have websites which EU people based in the EU can access, and if those websites are running lots of cookies, plugins, pixels, etc., those cookie items, if they're collecting data of individuals based in the EU, then they are also going to be subject to the rules of GDPR. So I understand the approach to just assume everyone is subject to the regulations and then apply them blanket like. But there are definitely ways of properly analysing your business, asking more and better questions about the data sets that you have and how or have acquired, and then taking a view based on that. But I agree, it's difficult if you've got very large sets of data and perhaps not a lot of information around the background to those data sets.
And then from the organizational and technical perspective, what are some of the conflicts or constraints that act against some of the efforts that they might try to put in place to implement data protection, whether it's because the technical systems design that they have doesn't really allow for proper segregation or tracking, or whether it's a matter of policy as far as helping the different people within the organization understand the importance of these different regulations and their enforcement?
Yeah, it's a really good question, actually, Tobias, because there are a number of reasons, I think, that we see conflicts, constraints. I mean, the biggest one that certainly Mark and I think is, first and foremost, you need management buy-in of the need to understand the regulations and implement appropriate standards into your organization in order to be compliant with them. This goes back also to the codification of trust that Mark talked about earlier on. It really is a trust journey, not only with your customers but also with your employees. I think lots of data scientists and data analysts want to do the right thing, but if organizations don't train them in what the right thing looks like, or if organizations don't give them the tools in order to do their job in a way that is compliant and meets the standards, it's hard for them to be able to do the right thing in a way that they would like to be able to do it. So management buy-in is really important. And also, it's an investment in your business. And sometimes going through a compliance program, you can identify cost-saving measures in your business. If you do a proper data audit, data discovery, you map out your records of processing activities, you might find activities going on in your business that are unnecessary. You might have systems that don't need to be used or paid for. So there can be benefits that can be gained from these compliance programs, aside from the obvious being compliant. And also sales and marketing departments often are in conflict with some operational departments or compliance departments because they've got different goals. Obviously, the sales and marketing teams want to generate leads and get money in the door, but it has to be in a lawful and compliant way.
I think one of the areas where you kind of see differences is if you think kind of most IT departments are concerned with security of the data, all the usual things on security, which is I think of as protecting the perimeter. Mm-hmm. Then you can think about the kind of compliances within the perimeter. So, for example, if too many people have access to personal data, if people are monitoring if people are applying least privilege within the organization, so too many people have got access to it, then that starts giving you a data protection compliance problem. Now, in fact, there's a good example in Portugal the other day, which is obviously in the European Union. There was a Portuguese hospital which had something like, 50 doctors, and there were 200 people in the organization who had doctor-level access to patients' records. Okay, so that gives you a good example. That's not a hard, it's not like the server hasn't been correctly hardened. I mean, everything's working like it should do. That everything's been patched correctly. It's just there's a laxity
business level.
At the business level. No one's really thinking it through about, well, actually, there's trust here. We've been trusted to hold onto this data and protect it properly. But actually, that would mean revising or checking each time who has access to what data.
And, I know we were talking about conflicts and constraints around the efforts to implement data protection in organizations, but, it's also important for organizations to realize that, supplier due diligence, I'm sure many of your listeners will have gone through an RFI process, or you've had to fill in a due diligence questionnaire for a large client. GDPR and data protection compliance is often a big part of that due diligence process. And you may not actually get the business unless you have certain standards and procedures in place.
Another thing, too, is that the initial era of big data was just capture everything because you never know when you might need it. And a lot of the current trends are pushing in the opposite direction of don't collect it unless you know that you need it. So it's interesting to see how that has been manifesting in the industry in terms of the technology choices that people make, as well as the conversations that people are having as far as how to approach analytics and data collection and data management.
I think it's great that the conversations are being had and that the trends are changing. I think that shows a big awareness now of data protection in and of itself.
And then one of the big challenges in these technical implementations and in these systems designs is understanding what data you have, where you have it, who's accessing it. So I'm wondering if you can talk through some of the challenges that you've seen people go through and some of the solutions that they've come up with to approach that idea of just understanding what data exists and how to properly maintain and secure and protect it.
Yeah, I mean, that is a great point, actually, because understanding what data you've got in which systems, where it came from, who's got access to it, where it's stored, is a foundational step on your data protection compliance journey. Until you've done that exercise, it's actually quite difficult to do things like build out accurate privacy notices or put decent processes and procedures in place, even including things like data handling. So my experience with my clients is it's one of the hardest exercises for them to do if they haven't previously done it. So, if you're a smallish organization, you can take a super simple approach like capturing it in an Excel spreadsheet, but even that is a very time-consuming exercise. Luckily, on the market, there are a number of different tools that can be used. There's data mapping tools, things that can map out your data flows. You can enter into which systems your data is stored in, who the processors are, where they're located. So there's tools out there that allow you to capture all that data audit or data inventory information. And that is something that I would fully recommend an organization invest in, because once you've done it, it's just a case of maintaining it. So that's the first thing that I would suggest on that one.
Yeah, interesting. I've also done it some low-tech ways. I had a company that asked me, this is where the GDPR helped them kind of get from where they were, which wasn't very good, frankly, to a good data protection regime. And I bought a large roll of wallpaper, line paper, and it becomes very cheap. There's a lot of it, and sliced it up and stuck it up on the wall. And we had kind of war room. And I kind of worked out, we knew roughly what kinds of data were coming in, and you could do a kind of data in, okay, that's that. Data comes in, data's held, okay, that's that section. Data out, that you have a kind of life cycle of the data, and you could work through all that, and then you could get, scribble bits on there, post-it notes, you could stick it up. It was quite very analog, very old school, but you could get a lot of people involved. You bring in, and you can't just be the IT guys, can't just be the data guys, can't just be the kind of compliance people. It has to be everybody in there adding their, talking about it, sticking their bits of information up. So that worked quite well. One of the interesting outcomes is we went into the company thinking it had held 2 million records covering 2 million people. By the time we finished, we realized they held records covering 30 million people, which is which is a bit of a discrepancy. But no one had really thought about it, right? Everyone was just doing their normal job, working quite hard, but
in their silos.
In their silos.
Yeah.
And one of the things that works that you kind of realize is this is not a silo. You have to kind of remove the silos to get it to work well.
It needs involvement across every department within the organisation. It's not just an IT project, which is perhaps how data protection was seen before. I mean, I think most people would have linked data protection to data security. Well, it's more than that. Data privacy is the big side as well of data protection. But on the topic of tools that are available. The International Association of Privacy Professionals, I'm not sure if you're interested, your listeners might be interested. Every year they produce a privacy technology report, and they list out all the vendors in the privacy tech space. And there's some really interesting information in that report. And I can certainly send you a link to that afterwards, Tobias.
Yeah, I'll definitely be interested to take a look at that and see what types of systems they've got in their purview. And another thing that plays into the idea of data protection and identifying and auditing the data flows is another big challenge in the data management space of data provenance, which covers everything from what you were describing of data in up through data out and into the point of doing analytics or machine learning to figure out what records are actually being used, what attributes of those records are being used within those machine learning workflows to be able to make sure that you're not either inadvertently exposing information or inadvertently including information that's not actually necessary for the conclusions that you're trying to derive.
Exactly. Data provenance is hugely important, especially if, I think in one of the examples, if you're part of a project team and you're given a large data set and you have to go and tidy up, do the data preparation, for example, on it, who is going to be asking the questions around why have we got this data? What are we allowed to do with it? At what point in your life cycle of obtaining, preparing, storing, securing, then using that data, are those important questions going to be asked?
And interesting, so one of the things I've seen done, which I think works well for companies that are taking big data sets in and out, is applying a bit like when you arrive at the airport, you got to go through the customs guys to check you. The ones who are checking your passport, you're going to go out. And one of the things I've done in some of these engagements is put in similar kind of things for data, right? So you can't import any data in the system without some kind of analysis of what the data is, where it's coming from, what rights attach, and so on. And then there is some mechanism within the company which allows that data to come in. It doesn't come in automatically. And the same thing for when you send data out. And in fact, that was big movements of data. And one of the things we were discussing about, and this is a company who did a lot of processing data, so it might have financial data, some have data, fairly sensitive data on a number of people that you might send it out to a third party to take a look at, and it would be an attachment in an email. Of course, you never quite know where the attachment's going to end up. So we started kind of to change that. So you never send the attachment out, you send a link to a data room. So you can then, when the person you sent it to comes and looks at the data, it doesn't leave the location in theory, but at least, if you see what I mean, but at least there's an audit trail of how the data is getting accessed. It's that kind of thinking.
And then another question that came up when you were discussing bringing everybody into the same room to map out all the different ways that the data is being used and discovering that they actually had, several multiples more records that they needed to be concerned about than what they had originally thought, is the idea of who's actually responsible for making sure that an organization is considering all of the different implications and ensuring that the company is appropriately in compliance with the different regulations and even identifying what regulations they're subject to.
Yeah, and that's an interesting one to talk about, because I mean, obviously, ultimately, the board is responsible, but in a large organisation, responsibilities would need to be shared and appropriately defined. So I've seen it where you might start from a basis where you've got someone who's a system owner of each of the systems that you've got, and they would then be responsible for the data within those systems. And then if an organisation is large enough, they might have a privacy team, for example, and the system/data owners would then have dialogues with the privacy teams. So it is really important to get back to the foundational step, which is your data audit and your data inventory, understanding what you've got, in order then to be able to appropriately assign the responsibility for certain aspects of data protection within the organisation. And larger companies as well could have, chief data officers. I've seen that used quite a lot in some of the big banks. And even in tech startups, for example, just because they're startup and they're small, they might have hundreds of millions of records. Well, they still need somebody in their organization who's responsible for data protection. And if they don't have the skills, they should go externally and source those skills.
Yeah, you should have some kind of, data, some kind of operating model, right? So you know how it works, and you should, and you should have some kind of monthly governance. So every month, the different disciplines get together and you have a standing agenda, you can work through them. And, things like vendors, right, suppliers. So if you outsource some of your processing to someone else, well, you're still responsible for that data, even though someone else is processing it for you, right? So who's checking up on the vendors to making sure they're doing what they should be doing? They've got good security and all that kind of stuff. So, although probably one person at the end, will be responsible, in the hierarchy, as an operational execution, it tends to be a distributed responsibility for different people bringing their different angles in. And if they don't have a kind of regular spot at which to meet and discuss issues, that means it's more likely that issues will get missed.
And it all starts from training and awareness. You have to give, I think I mentioned earlier, you've got to give your employees the chance to be able to do the right thing. And it's only fair to them. They get the training to understand what it is they need to be doing.
And then as a corollary to the idea that we were discussing earlier of tracking and auditing the information that we're storing and using, is in the GDPR, at least, there's the right to be forgotten clause, where a company needs to be able to thoroughly delete information pertaining to a given individual, which can be quite complicated, especially when we're dealing with complex systems with multiple different storage layers or multiple different pipelines that are replicating bits and pieces of information throughout. And so I'm curious what you have seen as far as challenges at the technical and organizational level, and some of the strategies and technologies that they have found useful for being able to follow that regulation.
Yeah, good question. Interestingly, in Europe we got I think it's 6 or 7 data subject. We call them data. Technically, then consumers known as data subjects. The right to erasure, the right to forgotten, the right to get access to your data, the right to corrections, the right to this, I can't remember them all, but it's either 6 or 7. Now, although the right to be forgotten grabbed most of the headlines, the one that's mainly exercised is the data subject access right, the right to get a copy of the data held about you. Okay, and that exists in the GDPR, that exists in the CCPA, and you get the same issue, right? Multiple systems and so on. Now, talking about the subject access right to begin with, it's not you have to go to the ends of the earth to produce everything, but you've got to make a reasonable effort. Clearly, if you've got a coherent system with everything in the right place, it's easy to do. If you're straddling 6 or 7 legacy systems, and it gets much more complicated, a good reason to get rid of data you don't need, to be frank, because then you don't have to report on it. In terms of the right forgotten, the right of deletion, it's not an unfettered right. It's not unqualified. So if I've got a contract with you and you're still a customer, you can't just have your right. You can't say, I'll just delete all my data. Well, I can't do that. I've got a contract with you. Even if the contract's over, there's reasons you can refuse. For example, you're allowed to hold on the data if you think that you might need it for legal, in contemplation of legal defence at some point down the line. So it's not as unlimited as you might think. Now, the UK has always been a bit more business friendly about this kind of stuff than other bits of Europe, and we're still in Europe for the time being. So things. I mean, there's always been accepted that you could hash some of the information, and that would basically count as deletion. The UK used to have this thing called putting out of use, where for some reason you might not be able to delete all the data, but you could park it somewhere where it was not accessible or not easily accessible to the business. It require 2 or 3 sign-offs, so it's difficult to make be accessible. And you can take those kind of protections. It's not as despite this the exciting name, the right to be forgotten. In most businesses, as a practical matter, it doesn't come up that often. It's not an unqualified right, and it causes less issues than you might expect.
So, just to follow on from what Mark was saying there, the challenges to that, whether they're deletion requests or subject access requests, in a complex ecosystem where you have a number of potentially interconnected systems, the first step in overcoming some of those challenges is, again, this foundational step we've already talked about, which is understanding what data you've got where, why you've got it, etc. Once you've done that, there are then a number of tools on the market. So coming back to the privacy tech sector, there are data discovery tools that can assist with working out what data you've got where. But also, I've also seen some tools where they can bring you up a single view of an individual and allow you to perform deletion requests in a much quicker and more automated way. So, yes, there are solutions on the market to be able to assist with some of the complex and time-consuming requests that you may get. But it's always important to do 2 things. One is understand whether the request is one that is valid under the regulations, and 2, have done your homework on your systems and your processes to understand what's where and actually how much of a task is this that you're going to have to undertake.
And then another layer where this manifests, particularly in terms of updating data or having a customer elide bits of information from their records, is how it's being used in downstream use cases, whether it's business analytics or doing some sort of machine learning on aggregate data, and how that plays into the need to either regenerate a model after it's gone through a training regimen once you get the data updated, or how the data is actually being used, or what particular attributes of a record are being used within those analytics, and some of the technologies and techniques that are viable for still remaining within compliance of these regulations, especially as far as some of the explainability requirements that come up.
So yeah, these are the $1,000,000 questions, really. I think we're getting into now. So yeah, definitely. Once we're starting to go downstream from the data collection, and we're using the scientists and the analysts are starting to run searches across the data, etc. It still comes back to the organisation's responsibility and requirement to provide the scientists and analysts with a decent, clean set of properly obtained lawful data. So if then data scientists or analysts then want to access data within that data set that could be protected, there should be appropriate controls or tags or logging or audits that the scientists and the analysts can see and be aware of when they then come to go and do the projects that they've been assigned to do. And it's also possible as a way of embedding that, the management of that at the beginning of a project. If scientists or analysts or even project managers running a project that involves the scientists or analysts, they do a privacy impact assessment on what the project aims to achieve. So if the intended outcomes from the project are those that might result in the creation of profiled data sets upon which decisions will be made, then really at the beginning of the project, they should do some sort of impact assessment of what data they're going to use, are they using it in a lawful way, and what safeguards they'll put in place for the results that are generated from that particular project.
So yeah, looked at another way. So if you go back to the beginning, the point we're talking about right being about trust. Okay, so you've got your data set. So the question is, what consents have you disclosed, right? And then what are the reasonable expectations of the consumers? Are you acting within that? Now, if you want to go beyond what was disclosed under GDPR, you can do that, provided it's kind of akin in the same ballpark. But you typically need to inform the data subjects that's what you're going to do. That's an initial constraint. Now, of course, GDPR applies to personal data. If you anonymize the personal data, and anonymization is a sliding scale, as we all know, so let's say if you sufficiently anonymize the data, then it stops being personal data and you're not regulated by the GDPR anymore. You can do what you want with it, provided someone can't come back and reverse it back to the original players. But if you can't do that, then you have to kind of act within the initial parameters. And that comes back to the thinking about what you need to begin with and thinking it through, planning it through. In terms of there's kind of various. So the GDPR has a thing about automated decision making, okay, and profiling, and it's not forbidden. You're allowed to have profiling. You're allowed to have automated decision making, or you're allowed to have automated processing, provided you've done the correct disclosures. The issue is where you have automated decisions are taken, right, without any human involvement. In that case, if you're doing that, you have to disclose that, and the person about whom the decision is taken has the right to object, has the right to have an explanation as to how the decision was taken. And then that brings us into things you were talking about, interpretability. So if you've got some machine learning which is pumping out decisions, and you can't explain, and then you can't explain how the decision was reached, that starts to give you a bit of a problem, both in GDPR, in a GDPR sense, but also in the more practical sense as well. As is there some bias against a particular kind of people? That's happened in the past before, even without. I mean, one of the concerns is that machine learning will have inbuilt biases, which is slightly odd because we know that humans definitely have inbuilt biases. So yeah, those are the kind of new kind of cutting edge issues that people are wrestling with, how to do that. And there's a lot of thinking and discussion and kind of guidance about it. I mean, part of what I'm hoping to see is AI, which validates AI. Okay, so you have a test data set and you run it through, and if it produces the right answer each time, it's working, and maybe something like that. Does that help?
Yeah, that's definitely useful. And some of the topics of bias too comes back to the data engineering layer and data collection, as far as trying to identify potential biases that exist in the data sets, and then either seeking additional or alternative sources of information to complement that, or to at least annotate the data set to say this is a potential source of bias, so that the people who are performing the analysis are aware of that and can try to counteract that in terms of the algorithms that they apply to the data to make sure that they try and strip out some of the bias. But as you said, we're all human. All the computer algorithms that we use are written by humans, and so there's no way to completely divorce ourselves from bias, but we can at least try to identify and account for it.
Agreed. And there's some examples where actually it's quite easy to use the machine to remove bias. So if you've got a lot of CVs coming in, you can take out all the references to sex. You could take out all the age references. You might have to take out all the unusual foreign-sounding names, replace them all with Smith. If that's the kind of background you're from. And so there are ways which the machines will actually help counter human bias as well. In fact, we'll send you the link. There's some very interesting work done by the UK ICO on this kind of stuff. They've got I think it's called, I'm looking at Karen, it's called an AI audit. AI audit framework. And they've got some kind of guys in it's kind of think tank work as to what strategies or what steps should you go through to make your development of machine learning successful in all the senses of successful. In fact, I saw a job ad the other day about who needs to be involved in machine learning, and one of them was described, and one of the new job I'd never heard of before, as an ethicist, which is like a practical, say Thomas Aquinas, a bit like the guy in the man who's married to Madam Secretary, if you ever watched that, Professor of Ethics, but with a practical application.
Are there any other aspects of data protection and the regulatory frameworks that we should be considering, or ways to keep up to date with the regulations that are present and new ones that might come out that we didn't discuss yet that you think we should cover before we close out the show?
Well, it's definitely a fast moving world at the moment. I mean, data protection's been around for a while, but the data is moving faster. The issues are moving quicker. You can listen to podcasts on data protection if that's your thing. You can link to feeds to staff, attend conferences. I would say, artificial intelligence is going to be a big one going forward. If you're interested in programmatic advertising, that's another big one. There's been a lot of movement on that coming up soon. I think probably those are the main ones I would personally call out at the moment. Don't know if you have other views, Karen.
Well, what I think would be useful would be the opportunity for data protection to be talked about perhaps more regularly at some of the engineering or technology conferences that happen. I remember I listened to one of your other podcasts where they were talking about the Data Council, which is a meeting, is a conference for engineers and developers, quite cutting edge. And I had a look at the conference online, and I didn't see any topic that covered data protection. So, back to my point about giving employees and engineers and analysts and scientists the knowledge to allow them to do the right thing. If data protection could be, brought into more of the syllabus, perhaps for those technical conferences, I think that would be really helpful.
That's for privacy by design. Is the word.
And bring in privacy and help them understand privacy by design, getting it right in the beginning. I think that would be really helpful. It's hard to keep up to date with everything, I have to say.
Well, for anybody who wants to follow along with the work that you each are doing and get in touch, I'll have you add your preferred contact information to the show notes. And as a final question, I would like to get each of your perspective on what you see as being the biggest gap in the tooling or technology that's available for data management today.
Well, I will answer a non-tool thing. I think it's not a tooling, in my view, it's not a tooling issue, it's a cultural and leadership issue. Once a kind of culture and the leadership in an organisation is aligned, then the right things start to happen and naturally flow out of it. And I'll hand over Karen to a more tool-based view.
I do have a tool-based gap, actually. Subject access requests, which Mark discussed and we talked about earlier, are very time-consuming requests for almost every organisation. Larger companies can invest in some of the sophisticated tools out there in the market to help them automate subject access requests, but a lot of human decision often needs to go into them. And what I'm not seeing at this point is a subject access automation tool that's accessible to organizations that aren't just the big organizations. So something's a bit more, maybe a lower price bracket, say, to a big enterprise-wide privacy management system. So that's would be my gap from my perspective. But certainly the privacy tech market is a really interesting market. There's lots of solutions and tools out there. There's over 275 vendors out there in the market now. There's $500 million a year being invested and growing into tech startups in the privacy space. So there's a lot of technology out there in the market to help different organizations.
Well, thank you both for taking the time today to join me and share your expertise and understanding of the data protection space. It's definitely something that, as you said, needs to be discussed more broadly and more widely understood. So thank you for all of your efforts on that front, and I hope you each enjoy the rest of your day.
Thank you very much, Tobias. It's been a pleasure.
Thank you. Thanks, Tobias.
Listening. Don't forget to check out our other show, podcast.init, at pythonpodcast.com to learn about the Python language, its community, and the innovative ways it is being used. And visit the site at dataengineeringpodcast.com to subscribe to the show, sign up for the mailing list, and read the show notes. If you've learned something or tried out a project from the show, then tell us about it. Email hosts at dataengineeringpodcast.com with your story. And to help other people find the show, please leave a review on iTunes and tell your friends and coworkers.
La 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 la.